Our first question, and there is still time to get your questions in, ladies and gentlemen. First question is for Brooke. Am I required to pay my public sector employee who takes a leave of absence for military training?
Sure. So this is Brooke. This is kind of a related question that often comes up when I'm dealing with these military issues and FMLA leave. But it's kind of an aside issue to the FMLA question. But I have had cases where many of my employer clients have, particularly in the public sector, often police force or fire, they have individuals or officers who are taking leaves of absence for military training, and they want to know if they have to pay them. Well, this type of training is protected by federal law, which is USERRA, and often by most state laws. And just briefly, USERRA guarantees an employee returning from military service or training the right to be reemployed at his or her former job at a nearly comparable job as possible with the same benefits. And then often, so I'm in Florida, I'll use Florida as an example. Florida has a statute which provides leave of absence for training for military exercise for up to 240 hours, which is essentially 6 weeks or 30 days, with full pay and benefits. So my advice to individuals who are facing this should look at their own individual state law to determine whether something applies.
Thank you so much, Brooke. Another quick question for yourself that's dropped in from the audience. How long is one required to hold a position of an employee who perhaps has recently taken a leave of military absence? Would that be something that's agreed before the leave of absence, or is there a defined length of time?
So beyond the 240 hours that I just mentioned in the Florida case, USERRA, which is the federal law, protects the job of the military leave employee for up to 5 years. And that's often something shocking to my clients, that they have that length of protection, which obviously can put have a big impact on the employer. However, USERRA does not require the employer to pay the employee during that time. So bottom line, the employer has to reemploy or reinstate the military leave employee even after they exhaust whatever initial hours are allowed pursuant to their state statute, as long as it's within the 5 years prescribed by USERRA.
Thank you so much. I know we're in danger of going into overtime here, but I think we can squeeze in one more question. Amy, this is for yourself, but our other panelists are welcome to chime in as well. Amy, you discussed the recent proposed changes to the FMLA forms. What changes do you expect to see in said forms from the Department of Labor in the upcoming year?
Well, I think, with regard to the forms, I think the proposed forms as they were proposed in August likely will reflect the changes. It will really depend on what the comments are. And we have not seen those comments yet. And I imagine they did receive quite a few, given, they've been talking about this for quite some time. So I think, it remains to be seen what types of comments the Department of Labor got on the forms as to whether they will include all the proposed changes on the proposed forms that came out in August, or if they will modify them additionally based on those comments.